Greetings, I am Polemopicus. Welcome back to our discussions of legal terms and concepts. You've heard that courts demand transparency, and they do, but transparency has limits. The law does not require one side to reveal how it plans to win. Notes, strategy, mental impressions are shielded from disclosure for a reason, because if preparation itself were exposed, the adversarial system would collapse. That shield is called work product, and today we examine where the line is drawn.
In discovery, the general rule is openness. Each side must produce relevant information. Documents are exchanged. Witnesses are questioned. Facts are brought into the open. But there is an important exception. Not everything must be shared. Some materials are protected, not because they are irrelevant, but because forcing disclosure would undermine the fairness of the process itself. That protection is called the work product doctrine. It draws a line between discoverable facts and the internal preparation of a case. Understanding that line is essential to understanding how litigation actually functions. The work product doctrine protects materials prepared in anticipation of litigation from being disclosed to the opposing party. This includes things like attorney notes, legal strategies, mental impressions, case theories, investigative summaries, draft documents, and internal communications about litigation. The key idea is this: each side is entitled to build its case without being forced to reveal its strategy to the other side. Litigation is adversarial. If one side had full access to the other's internal thinking, the process would become fundamentally unbalanced. The work product doctrine is rooted in the idea that attorneys must be able to prepare cases freely. If every note, draft, or internal analysis had to be turned over in discovery, several problems would arise. Attorneys would hesitate to record candid thoughts. Case preparation would become less thorough. Opposing parties could exploit internal strategy, and litigation would become inefficient and distorted. The doctrine exists to protect the integrity of preparation. It allows attorneys to think, analyze, and strategize without fear that their internal work will be used against them. Work product is often confused with attorney-client privilege, but they are not the same. Attorney-client privilege protects communications between a client and their attorney made for the purpose of obtaining legal advice. Work product protects materials prepared for litigation, regardless of whether they involve direct client communication. For example, a lawyer's handwritten notes from an interview may be work product. An internal memo analyzing legal strategy may be work product. A timeline created by an attorney may be work product. The two doctrines sometimes overlap, but they serve different purposes. Courts often distinguish between two types of work product. Ordinary work product includes factual materials prepared in anticipation of litigation, such as witness statements, chronologies, collected documents. In some cases, ordinary work product may be discoverable if the opposing party shows a substantial need for the materials and an inability to obtain the equivalent information by other means without undue hardship. Opinion work product includes mental impressions, legal theories, and strategic analysis. Opinion work product receives much stronger protection. Courts are extremely reluctant to require disclosure of an attorney's internal thinking. This is considered the core of the doctrine. Not everything an attorney creates is automatically protected. To qualify as work product, the material must be prepared in anticipation of litigation. This raises an important distinction. Routine business records are not work product. For example, regular business emails, standard reports, or operational documents created in the ordinary course of business. These may be discoverable. But if a document is created because litigation is expected or ongoing, it may fall under work product protection. The purpose behind the document matters. Work product protection is strong, but it is not unlimited. As noted earlier, ordinary work product may sometimes be discoverable under specific conditions. Courts balance the need for the information against the importance of protecting preparation. However, even when disclosure is ordered, courts often take steps to protect sensitive material. For example, a court may redact portions of a document, limit how the material can be used, or protect opinion work product entirely. The goal is to allow necessary access to facts without exposing strategy. From the outside, it may seem inconsistent. On one hand, discovery requires openness. On the other hand, work product allows concealment of certain materials. But this balance is intentional. Discovery ensures that relevant facts are shared. Work product ensures that how those facts are used and analyzed remains protected. Without this protection, litigation would become less strategic and more mechanical. Attorneys would be forced to reveal their thinking. The adversarial system would lose its structure. The system is designed to reveal facts, not strategy. Several misunderstandings arise around work product. If it's relevant, it must be produced, not necessarily. Relevance alone does not override work product protection. If a lawyer wrote it, it's protected, not necessarily. The document must be prepared in anticipation of litigation. Work product means the other side gets nothing. Incorrect. Facts are still discoverable. The protection applies to how those facts are organized and analyzed. In real litigation, work product shapes how attorneys prepare cases. It allows them to develop strategy privately, evaluate strengths and weaknesses honestly, prepare witnesses carefully, and analyze opposing arguments. It also affects how discovery disputes are resolved. Parties often argue over whether a document is a routine record or protected work product. Courts must evaluate both the content and the purpose of the material. The work product doctrine exists to preserve fairness. It ensures that each side can prepare independently. Strategy is not exposed prematurely. The adversarial process remains balanced. It is not about hiding facts. It is about protecting preparation. The legal system requires both transparency and protection. Facts must be shared, but strategy must remain private. Work product is the doctrine that draws that line. It allows attorneys to prepare their cases fully, honestly, and effectively, without being forced to reveal their internal thinking to the opposing side. That balance is essential to how litigation actually works.
If you like this content, then kindly hit like, subscribe, and share. Caesar commands it.